questions, anything, I post the link for digitized papers of the book. Hopefully that will probably not solve your problem, because we couldn't digitize the first week's ones and then the next week's, but there are only like 10 pages for next week, and it won't be the end of world if you can't read that 10 pages. Okay, it's like the other sources will give you enough information. Okay, do you have any other questions, anything? Also, Marta posted about the essays. I think so. That issue is also sorted. Anything? Any questions? Any comments? No? Okay, good. So remember last week, as usual, we couldn't finish our slides and topic in general. So, but it's okay, because last week, so this part, Article 101 agreements, and also what we will talk about today, Article 102, are the basis of everything that we will talk about, okay? And next week we will talk about standardization, standard essential patents, and as you will see that actually that will build on what we already learned in terms of Article 101 and 102, okay? So our aim is to finish everything within that 4 seminars, and I think we can do this, okay? So if you probably you remember, last thing we were talked about, and this is not working now, examples of how how the exploitation of patents, copyrights, and trademarks can create competition law concerns. That was the last thing we talked last week. And we left at agreements concerned with IPRs, okay? Do you have any questions so far in terms of Article 101 as well? No? Okay. So agreements concerned with IPRs, I mean, obviously these are not the only ones, but you can say that these are the ones mainly concerned with IPRs and most common forms. The first one is patent licensing agreements, obviously. And do you remember what's licensing? What's licensing?
To let other people to explore your patent.
Yes, so granting your right, okay? Then we have research and development agreements and settlement agreements, and particularly we will talk about pay for delay agreements, okay? I put standardization agreements there, but it's gray, because we will not talk about this today, but we will talk about that next week, okay? But it's still agreement concerned with IPRs. Let's start with patent licensing, okay? So let's first talk about the type of licensing, patent licensing. By the way, even though I said IPRs, I will talk about patents, okay? Because patents are the IPRs that we will mostly see when we are talking about intersection of IPRs and competition law. So patent licensing agreements, if we talk about the types of, first we have traditional patent licensing. So what do you think, what's traditional patent licensing? Traditional patent licensing, we said that licensing is actually renting. So what, how you describe the traditional renting relation?
I have the patent and you don't have an license to you.
Yes, so
I give you the license.
Okay, and what you get in return?
Money or
Okay, so you are renting your right and you are getting money. Okay, this is and what we call that money?
Royalty.
Yes, royalty. Great. Then we have cross licensing. Okay, can you think what is cross licensing? We talked about traditional one. So what do you think cross licensing?
you have patent and I have a patent. I give you my patent and you give me your patent.
Perfect. So cross licensing, no royalty involved. I have patents. What's your name?
Dean,
Dean has patents. I'm licensing my patent to Dean, and Dean is licensing his patent to me. Okay, and it is really common especially in technology sector. Okay, like for example, you can think about Apple and Samsung. Rather than paying royalties to each other, they are licensing their patents to each other. Okay, and then we have patent pools. So what is patent pool? It's form of licensing patents, different than traditional one and cross-licensing. Do you have any idea? Maybe you can think about like pool, the concept pool. So why we called it patent pools?
So you have a patent, so you can do it, but the owner of that patent cannot use their patent.
Okay, you have patent.
You get it from the owner of patent.
Okay.
The owner of patent cannot use it.
Okay, I know what you're talking about. Yours is more in this region. We will talk about this, okay? Pool. So when we talk about pool, what is pool? Patent pool,
swimming pool.
swimming pool, okay? Use your imagination. So what do you think this patent pool? Form of licensing?
It's like
Definitely more people involved. Okay. What happens is that in patent pools, patent owners come together, okay? Generally like multiple patent owners, and they are creating this pool of patents, okay? And these patents are related to each other. They are not like a random patent. So let's say, and again, I'm thinking about technology sector. For example, let's think about 5G technology, okay? There are like several, I don't know like how many, but probably like thousands of patents related to that technology. And even you can categorize these technologies like in small parts as well. And when you have that kind of situations, part of these owners of these technologies can come together and say that, okay, let's create this pool, put our patents in this pool, and then license the pool, like all the patents in the pool to outside world, and also they license it to each other, okay? So there are two types of agreements in case of patent pools. First, among contributors of patent pools, so patent owners, and then individual licenses they are granting to third parties. Okay? Are we clear about patent pools? Oh, I'm almost done with this room, and I still cannot figure out like how to deal with this temperature. Now it's too hot, I think. Okay. Are you clear, or I will? Okay. Then, before moving to exclusive sole and non-exclusive, vertical and horizontal. So, are we? Do you remember vertical and horizontal agreements? The difference. So, what's the difference? I want to hear from this side. I think this side is more awake today. So, this side. What's vertical and horizontal agreement? You need a hero now. I will help you.
Come competition.
Yes.
Horizontal is an agreement between competitors, and vertical is between non-competitors. So basically, a distributor and a manufacturer, for example.
Okay. Thank you. So vertical, if they are different levels of the, if they are different levels, and then if they are competitors, then we call that horizontal. Okay. So licensing agreements can be licensing agreements can be horizontal and vertical, which means there can be licensing agreements between competitors and non-competitors, but particularly depending on the type of licensing agreement you have, you see that kind of agreement more between, for example, competitors. Do you have any idea in terms of traditional cross-licensing and patent pools, which one do you think can be mostly horizontal? If you think about the definition of this. Why? I mean, if you are cross-licensing, you want to have.
Like in the same type of interest. I don't know what word.
No, I get you. Like in terms of value, you want to have like equal value of patent in order to enter into cross-licensing. No, you don't want to license your patent in return if you are getting a patent that is not as valuable as your patent. So generally, cross licenses are between competitors. Okay. Then we have exclusive licenses. Actually, so these are. We are looking from a different perspective to licensing agreements. So what I try to say that, for example, traditional patent licensing can be exclusive, sole, or non-exclusive, or cross-licensing can be, again, exclusive, non-exclusive, or in general also patent pools can be like either one of these, okay? So what is exclusive license? It's on the slide. What do we understand when we say exclusive license? Actually, you taught something similar to this.
Like a monopoly. Like a monopoly because it's exclusive for one person only. Like they belong to you and nobody else is gonna have it. So you're the one that has it in the corporation.
Yeah. So in exclusive license scenario, you are licensing your patent, and as a licensor, remember the licensor, patent owner. And you can call this implementer. So in this case, licensor is licensing his or her patent right, and he promised to license that I will not license this right to any third party, and also I will not use this right, okay? So you will be the only one using that right. Because of this, we call it exclusive license, okay? Then we have sole license. In this case, licensor says, licensee that, okay, I will not license the same right to third parties, but I will keep using right myself, okay? And then non-exclusive license, basically licensors saying licensee that, yeah, okay, I'm giving you the right, but I am preserving the right to license this to third parties, and as well as I can use it myself, okay? So you will not be the only one using that right. Are you clear about this? Perfect. Which one do you think more dangerous in terms of competition? Exclusive license, yes. Because you are creating,
a barrier.
yes, only one undertaking can use one right, okay? So this can create barriers to entry depending on the patented invention you have, but it is actually, I mean, if you see exclusive license, you should be like alert and more cautious, okay? You have question? No.
No.
Okay. Because I'm so clear.
One question. What's the difference between non-exclusive license and open?
Can you just like louder?
Yeah. Can you tell me the difference between a non-exclusive license and an open license?
Exclusive license and
The non-exclusive and what we call an open license.
and
open. Okay, open license. So what do you mean by open license?
I read that in some books and I know
Okay.
everyone can use it.
Uh-huh.
Like when it's open, you just have to tell me.
Okay.
And then you can explain it.
So it's in general, what you're talking about is, for example, it's common for software, okay? And so you create this software and normally you have license to let people to use it, okay? But for example, and I think this is the case for Firefox, it is, its license is open and also it's open because if you have software in terms of developing or improving that software, you have to get a license from main developer. But when you have open source, for example, software, then it's open to anyone who wants to develop, improve the software. So you can say that I cannot say like 100% non-exclusive open license, but I think that it should be non-exclusive because then it cannot be open license. So if you're opening to everyone, it's definitely not exclusive. Not sole because you are letting everyone to use. So probably we can categorize open licenses under non-exclusive license. Okay. Patent licensing agreements. So we are talking about licensing agreements now. I just try to make it clear that. Yeah. Okay. Actually, I think the heading is not perfect one, but anyway. So we are talking about patent licensing agreements and potential anti-competitive provisions in these agreements. Okay. So first one is territorial sales restrictions. What does that mean?
Sorry, I have a the other slide. Non-exclusive, sole and non-exclusive entitled some type of royalty, or it can be like for free.
I mean, okay. In order to have license, you have to have remuneration. Okay, but it's also okay. Let's remember like a basic contract law, and I think it's like in same in all jurisdictions. No, you can say I am giving this to you for free. I mean, when we say what's the elements of establishing sales or rent agreement?
Consideration?
Okay, and price, yeah, consideration price. So I have to have something giving it to you, and you have to give a remuneration.
I mean because of what Claire said, she's talking more like, I think it's called Creative Commons.
Okay.
In that case, which I know you said it would be non-exclusive,
Okay.
but there's no royalty involved.
Yeah, but you still have license agreement. So and that in see actually you are using it. Like for example, when you download free apps, you are agreeing to license agreements, no? But if they are
would it be like any of those free? It won't be any if it's not included.
yes, because I mean, what I try to say is that when you say remuneration, it doesn't mean that it should be like just amount of money. Giving something for free can also be like considered as. I mean, I can understand where you're coming from, because when you think about it, yes, like if you give it for free, you can categorize it in like different forms. But in terms of licensing, it is possible, and we call them royalty-free license. Okay, and we will also talk about them next week. So without asking any money, any royalty, you can still license your right. But actually, it's a good question. Now I'm thinking is that because when you think about, we always say that license corresponds to like rent. But if you think about that, it's not totally okay. Something to think about. Good question. Okay, but it can be royalty-free and licensed at the same time. Patent licensing agreements. Any other questions about this one? I didn't think that this will be this controversial. These are the potential provisions that can be anti-competitive. And the first one is territorial sales restriction. So have you ever seen a licensing agreement, like proper like patent licensing agreement?
Franchise.
Sorry?
I thought that they are franchise.
Okay. Yeah. So see, this is also something. It's not always you not always have just licensing agreement. Licensing can be part of a bigger agreement, and in general in licensing agreement you have like so many provisions. Okay, so these are not the only provisions you will see in a licensing agreement. We are only like, for example, there will be provision about parties, the applicable law, or what will happen if one of the provisions are invalid or something. So there are so many provisions, but I'm only talking about the ones that can potentially cause concern in terms of competition law. Okay? So first one is territorial sales restriction. What do you think territorial sales restriction? Yes.
Is it that the licensee only can sell products in certain areas?
Yes, yes. So, for example, let's think about sole, the second one, sole license, okay? So, licensor can use it and licensee can use it, okay? And they are saying that, okay, you will only use it in France and I will use it in Germany, okay? So, they are restricting themselves in terms of territories. Why do you think this is a problem?
What do you mean for whom?
For competition law? For me, I'm really like,
Consumer or
Yeah, that's like this one. For the
but
consumer.
okay, then I will ask you, what's the concern of competition law?
Consumers.
Consumer
Is it only consumer?
and
competition.
Both.
Yeah, competitive process. Yeah, okay. But it's good. We are thinking. We are starting to wake up. And why do you think we don't like this kind of things?
For the consumer point of view, like you have less products in, if I live in the coast or in the whole, I don't know, in full one city, I wouldn't be able to have the products that are selling in another place because there's a restriction in the agreement.
Let's say there is no restriction. So I said, can you see this part of the board? Okay. So I said, France, and maybe it would be better like this. And Germany. And I'm saying that licensor can only sell it here and license it here. Let's say if we don't have that kind of provision, what can happen? No. We don't have that territorial restriction, okay? They didn't say you can only sell in Germany and I can only sell in France. What can happen?
They start competing within themselves.
Yeah. So this undertaking, let's say A and this is B. This A can sell to France, so there will be two competitors in France. and then we can sell to Germany, again, 2 competitors, even for a patented invention, okay? But if when they do this territorial restriction, they are eliminating that kind of competition, okay? And this is particularly important in EU. Why?
One market, it encourages people to compete each other.
Mm-hmm.
One market, so you can't reject them to compete with.
Right, and what is the third unique goal of competition law in the EU?
To create an internal market in the EU.
Yes, so we don't want to create barriers between member states, and with this, you're obviously creating barriers. But don't, this can be justified as well, okay? It's not always, it's not per se anti-competitive. For example, let's say you have this patented invention and you need to invest a lot into infrastructure or maybe build a factory in order to produce that patented invention, okay? And in this case, and this is just example, for example, this undertaking in France can say that, yeah, okay, I know we are having these restrictions, but see, my fixed costs, I'm investing heavily in order to manufacture that. I can only get my return if we have that kind of restriction, okay? And in this case, it can be, you can say that if we don't have that restriction, I won't have that factory in France, I won't produce that product in France, and probably consumers in France cannot access this patented product. So what I try to say is that in case of patents, you can play with things. You can say that you can justify why you have that kind of restrictions. And if you can really justify it with substantial evidence, economically, by showing your costs, then you can have that kind of restrictions, okay? But it depends. If you have a good lawyer, you can have it. Customer allocation.
Does it mean that you can only sell to certain customers?
Mm-hmm. Actually, it's quite similar to territorial one, but this time you are creating different groups of customers and saying that you can only sell this kind of customers and I will only sell to these group of customers, okay? And again, same problem. If you don't have that kind of restriction, let's say for that product, that patented invention, you guys are all potential customers and we have license agreement, me and Dean, and I'm saying, Dean, that okay, I'm licensing my right, but I will sell right side of this class and you will sell on the left side of the class, okay? If there is no that kind of restriction, Dean can sell to you as well, so we will compete for you as well, and then I can sell here, so there will be at least 2 competitors for you as well, okay? Field of use restriction. Yes.
So then you can only sell in a certain kind of market, maybe, or area?
Okay, but this is, and that can be true, but not always true, because we will talk about in the hopefully second hour about market definition. So it's something it's a technical terminology for us. Because of this, I'm using field of use restriction. So, but it can be true.
The license is allowed to use the patent in a certain way.
Yes.
So it depends on which makes the license or use it.
Perfect. Do you have anything to add?
No, I would have made an example.
Yes, good.
Let's say both have there is a software program, and one wants to use that for games, and the other one wants to use that for academic reasons. So they cannot change it. it's like again the same.
Okay, I'm so happy now. Yeah, that these are like perfect definition and example. Okay, and my example for this always is, and I think this is like a real life thing. For example, you have like a chip, like patented chip that you can use in like electronic stuff, and that chip can be used in toy cars, okay, and also big like racing cars, okay, same small thing. And when you license your patent, to, let's say to toy manufacturer, you say that, okay, see, you can use this small chip for racing cars, but you can't, okay? You can only use it for the toy cars, because if you can imagine, the value of that small chip for toys and racing cars are not similar, so they are restricting the use of that technology, okay? Yes?
So could you sell the same product for different prices to different customers then?
Okay, I will ask this question to you for this Article 102 part of the course, because that is related to that. Can you apply the similar prices to similarly situated undertakings for similar transactions licenses? Okay?
Get back to it.
Okay, tying and bundling. First question, what is tying and bundling? Okay. Someone say.
It's like keeping something together, but I mean they're all very similar. So it sounds like it's like the same. The others, territorial restriction.
Okay, let's go like one by one. Let's talk about tying. What is tying?
I don't know, but since we're talking about licensing, is it that the licensee has to license to different kind of products or patents?
Okay, forget about license. In general, what is tying? Because tying and bundling is in general like competition law thing, and I will give you the example how it can apply in this patent licensing scenario. But in general, if you are studying or like if you will practice competition law, you will see tying and bundling a lot in general. Yes, I have. Yeah.
Tying is when an undertaking is licensed for other conditions and another as well.
Okay. Do you have bundling definition?
Bundling is when it's all sold together.
Mhm.
As like maybe you have two products in the same package.
Okay, so they sound really similar, no? Is there any economist here who study economy? So for lawyers, they are quite similar. And when you look at, for example, judgments or anything related to these issues, you will generally see them tying and bundling, okay? They like, because lawyers, we love to cover all the grounds, we always like refer them together. And your definitions were like totally right. And if you look at, and it was in the reading list of this week's handout, this guidance on the enforcement priorities in applying Article 82, now Article 102. This explains what is tying and bundling. Yes?
For bundling, you are forced to get like both products together.
In bundling or tying?
Bundling, you're not. You just get like a discount or some like incentive. Like,
So you read this?
It's like printer and the color report.
Yeah. So this explains it that way. Yeah. So for example, for tying is, if you want to buy this, okay, you also need to. Can I use this one?
Yeah.
You also need to buy this one. Okay. I am not selling you this without, if you are not agreed to, if you agree to buy this one as well. Okay. I'm forcing you to buy this. Bundling is more of the way that you present two products together or how you price them, okay? So either I can be just like make them like this on the market and you can only buy them together, or they can be separate, but I can tell you that if you buy them together, the price will be lower than the price that you buy them separately, okay? From a lawyer's perspective, they are quite similar, okay? From economist perspective, and I asked this question to Mark, what is the difference between tying and bundling? Do you know Mark first? Yeah, okay. He's economist and he's like, you can say our boss in competition department here. And he told me the difference as from economist perspective. In tying, start with bundling. You have two simultaneous transactions at the same time, okay? You are making transactions for two products at the same time. Whereas in tying, there is one transaction at this moment, and then after that transaction is forcing you to make another transaction later, okay? And we can give, what's your name? Your name? Yes.
Mine?
No, your Glasgow, yeah.
My name is
Yeah.
Larissa.
Larissa, your example is perfect for tying, okay? So for example, you buy this laser printer, okay, from a, I don't know, like Intel is making printers, or Samsung is, I think, making printers, okay? Let's say Samsung.
Yeah.
So I bought this printer from Samsung, but it only works with inks produced by Samsung, okay? So it is forcing me, I make this transaction to buy the printer, then it's forcing me to buy their ink after that. Yes.
I think a very good example would be the new iPhones,
Okay.
because to listen to music you have to buy either the adapter,
Okay.
because there is no normal plug-in anymore.
Ah.
So you have to buy an adapter to listen to music.
Okay.
I mean, they create a new phone, but they create it with a problem, so we have to buy something else to listen to music.
Okay, but see, for example, in that case, are they allowing third parties to produce interoperable?
I don't know if they allow it, but I mean, if you go to Wish,
Yeah,
they
okay.
have the adapters as well.
Yeah, so this is the tricky situation. So it can be something like that, and it's really common. And for example, it's like a trick they use in technology sector. So for example, they are changing the adapters and they're fitting, so you cannot use the old one for the new ones, and so you need to buy new one, or but it's important whether they are letting third parties to produce that thing compatible with iPhones. But for example, for bundling, as you can see, I'm still confused. For bundling, I told the example of earplugs, okay? I think they are not headphones, headphones. So I think they are not giving it anymore, but when in the past, when you buy phone, it always comes with headphones, no? So that can be an example of bundling, because two transactions happening at the same time. Okay, why this is important, the first difference between tying and bundling? Why we are making all these explanations? They are different, there are different terminology. Okay, the difference is not important, okay? For a legal point of view, there is no, you can just forget about it, what I said about the difference and everything. Know it, because if someone asks you, you will really impress them by explaining this, but don't confuse, because, for example, I noted it to my small notebook, so I can just quickly check. But from a legal point of view, there is no practical importance for this difference, okay? This is something economists created, and anyway, and obviously we are right. Example of tying bundling for patent licensing. Can you think about example how tying bundling can be applied in patent licensing situation? Why I put this under the patent licensing agreements as a like a potentially anti-competitive provision? What you
Because, for example, if you buy the printer from Samsung,
okay,
and you have to buy the ink from Samsung as well,
okay,
there will be no other ink producer who will be able to compete with Samsung.
okay,
Because that printer is just compatible with its own ink.
yes, but my question is, what is like how you can use this tying and bundling practices in patent licensing scenarios? So you have this patent license, and there is that provision, or it is like allowing something that we consider it as tying or bundling, and we say that this can be anti-competitive. Okay, because question is not that clear. So you can tie patents together, okay? And this will be something we will again talk about more next week. For example, in terms of standard essential patents, I will explain this. You can bundle or tie essential and non-essential patents under the same license. So force undertaking the licensee to get license for both essential and non-essential patents. Okay? We will clarify that more, but so this can be something like anti-competitive in the context of patent licensing. Non-compete obligation. Okay, because our time is limited, I'm just like quickly tell this. So non-compete obligation is basically saying that if you are, let's say again, with Dean, I have this licensing agreement, and I said, okay, I'm giving you right to that patent that you can use to manufacture this, okay? And I'm telling him that you cannot manufacture any product that is competing with this. Why do you think I'm doing this? So I have a patent for this. He's licensing my patent, and I'm requiring him not to produce any product competing with this product. Yes.
He's got your pattern, so he can make something very similar to your product.
No, actually, no. But because he has my patent anyway, so he doesn't need to make the similar. He can just use it and make the exact thing that patent is protecting.
But isn't it the same to territorial sales restriction then?
No. I'm not saying him that you can only sell it here or...
I mean, like, not that it's territorial, but it's a sales restriction actually. If you tell your licensee that he's not allowed to do the same as you do.
Okay.
So that's a restriction.
But sale is more about like the action of selling something. What I'm talking about is before that. Like, so I'm saying that
the
you can...
procedure to
Yes.
make it.
So you cannot have similar product in your portfolio and you cannot sell it. There are someone, yeah. Okay. Field of use restriction. Actually, what you're saying is no. Because patent can be used in different, like, two ways, you're saying. No, in my case, you can only use my patent only to produce this. I'm creating this mystery.
I'm not sure if I heard, so maybe it's the same, but if the licensee can make something similar, then he'll create a product that will compete with the product he's already renting. Or no.
Actually, similar thing, okay.
I think it is similar to what Apple does.
Mm-hmm.
He asked the factory can only product the charging for Apple,
Okay.
not for Android.
Okay.
I think that is similar.
But in your example, that the manufacturing company has the licensing right of the Apple.
Yeah, it can product the charging for Apple.
Okay.
Charging line for Apple.
Okay. And do you know why they are doing that? What's the reason behind it?
I think maybe to I don't know how to say that.
It's okay. I think this is a hard one. So, in terms of royalty can be paid like lump sum, okay? Or you can say that periodically I will pay you that amount. Or they can say that you will pay me for the like certain percentage per the product that you are selling, okay? In this case, if you are producing competing products with my patented product, that directly affects your sales of patented product, which will affect my royalty gains, okay? So if Dean is producing my product, and I'm saying is that, let's say, when you sell this product, you will pay 1% of your profit to me as a royalty. And if he starts to produce this competing product as well, instead of, let's say, potential sale for this product is 100, when he starts to produce this well, probably this will go down, let's say, like 70 or maybe 50. That means that I will get less royalty from him if we have that kind of arrangement, okay? Does that make sense? Okay, great. No challenge clause. I'm licensing my right, but I'm saying that you cannot challenge what? Yes. Perfect. Validity of patent. Why? Why I'm doing that?
Because otherwise the patent could come up with like a similar invention and claim it as theirs.
Yes, but actually the main reason is when you, and maybe you remember from last week, I think, we talked about, first week, talk about patents and know-how, okay? So when you have licensing agreements, it's not only like, okay, this is my patent and you have the right, okay? Because patents are obviously the purpose of agreement to get that right and produce patented stuff without infringing it. But when you have patent licensing agreements, generally licensor gives so many information to licensee to enable her to produce that product in a really efficient way. Okay, for example, that can include know-how. And it is really important because the way that you explain your invention in your patent may not be the most efficient way, and while you are actually using your patent, you found out that, okay, if I do this like this, it will be easier, or in general, like in terms of efficiency, producing that patented product in a best and most cost-effective way. And licensor generally explain all this information to licensee, so licensee is in a really good position to challenge the patent. They know a lot of patent. Maybe they also explain how they came up with the invention. So because of that, licensor can, and most of the time, want to protect themselves from licensees, like all these information. Okay, why we think this is anti-competitive? I think it makes sense, no? If I'm giving you so many information, obviously I want you to not to use it against me. Why do you think this is uncompetitive? Yes.
Because you actually take some of the ability to maybe make a product similar, but for a different use. So this product could compete with his product. I mean, even if I have the patent.
Okay.
I mean, let's say it was my idea actually. Oh, like I have another idea and I want to combine them two, but I can't because he has this challenge clause.
Yeah, but the challenge clause is actually saying that you cannot request invalidity of my patent. So I'm saying that you cannot invalidate my patent. Why we think that preventing invalidation of patents can be anti-competitive? So let's go back to basics. What is patent right? What does it create? Someone said like monopoly. Yeah, exclusive right to use the subject matter of the patent. No, and if you have a patent for something actually not eligible for patent, you are creating this exclusive right to use it for nothing. Okay, and by preventing licensee to challenge the patent, actually I'm also doing bad for the whole market and for the whole economy, because it shouldn't be something patented, but it's patented, and there is a benefit for public if it's invalidated. Okay, and this no challenge clauses can prevent that. Okay, and because of this they can be considered as anti-competitive. Okay. Grant back provision, very quickly, it's about how the invention is actually cumulative. So generally, and like actually after like all these like improvements in humanity, you never, like not never, but most of the time you don't come with just like invention out of blue. Okay, there is already something. Okay, and remember we call that state of art. So there's already something there, and you work on it, and you improve it. Okay, so in grant back provision, again, it's related to disclosing so many information to licensee, as well as generally new inventions are made when you're already working on the existing invention. Okay, for example, for pharmaceuticals, they invent let's say like combination. Okay, so combination of two things good for like treatment of this, but there are some side effects. Okay, so they start to produce and use that, sell to human, but they also work on that combination, and they said, oh, okay, maybe if we change the percentages or if we add this to that, we can reduce the side effects. So it is not like a brand new thing, but it's actually improvement of what is existing. Okay, and grant back provision, licensor says licensee that if you have any invention when you are using the right that I license you need to license it back to me. Okay, so if your producer Dean was producing this, and then and there was like this was like a normal lit cup. Okay, and he said, oh, okay, it will be good to have something like this on top. It will be like more convenient to drink maybe on the go. And I'm saying is that, okay, if you do something like that, you have to license that invention back to me so I can use it. Okay? And technology transfer regulation is related to that, because in general it's about licensing. I will not go into detail because we don't have that much time, but it's in principle block exemption. Okay, we talked about block exemptions, what they mean, and if you satisfy conditions in technology transfer block exemption, your licensing agreement can benefit from this block exemption, so it can escape from Article 101. Okay, there are market share threshold, hardcore restrictions in terms of condition in the block exemption. And if you go and have a look, a special preamble is like quite helpful, and in general you can quickly read and understand like what kind of conditions you have to satisfy. And remember, I told this before, in general lawyers draft licensing agreements considering block exemptions, okay? If there's a potential block exemption that you can benefit, you have the block exemption and your agreement, and try to draft your agreement in a way that it will benefit from that block exemption. Any question about that? Okay. Let me see. Okay. I will try to finish these 2 slides in 5 minutes, okay? Then we will have 5 minutes break. Settlement agreements. In general, they are pro-competitive, okay? Why do you think they are pro-competitive? Because as they can prevent lengthy and costly litigations, okay? So undertakings can go back to their normal things, to do their normal things. But they can also be anti-competitive, especially in certain industries, and that industry is pharmaceuticals, okay? And the particular settlement agreement, which is like, can be like, create real serious anti-competitive concerns is pay for delay agreements. And what happens in pay for delay agreements, so when you have a patented pharmaceutical, let's say the price of your pharmaceutical is 100, okay? Because you are the only one producing that pharmaceutical and no one can produce it, okay? Still, it's a regulated area, by the way. I don't think that in any other in any country you can just like set your price. Generally, Ministry of Health or like there's this authority giving you some guidelines and regulating how you price your product, even it's patented. But still, you can set a really high price for your product when you are only one producing that product, okay? Once your patent expires, okay, you don't have patent protection anymore, generic can enter the market. Once generic enters the market, so let's take the copy pharmaceutical, like same pharmaceutical but manufactured by another undertaking, your price can drop like 60% around, okay? So you were selling it for 100 and it can drop to 40. So there is this huge, and that can be like more, okay? Because generic, the cost of generic is really low. They will probably price their product really low, and you need to compete with that product, because if you don't, in terms of price, everybody will buy generic and you will end up not selling your product, okay? For this problem, genius pharmaceutical companies came with this really good solution, actually. So what they are doing is that they are entering into settlement agreements with generic companies, and they are saying that don't enter the market, okay? So I will keep my price high, and I will pay you the money that corresponds to the profit that you could have made if you enter the product, enter the market, okay? So it's win-win. I'm still selling from this high price, and I'm paying your potential profits to you, so you are not launching your product, okay? Why this is bad? Who is the one mostly affected by this? Consumers, okay. And probably it's similar in many countries. Generally, state is the one harmed by this practice, because in most of the countries, the main buyer of pharmaceuticals are states. So if you have national security system, generally states pay for the pharmaceuticals. So that means that state is still paying 100 to that now not patented product more because of this practice. Okay, this is a serious concern. It was the case in Lundbeck case. Did you read what happened in Lundbeck in terms of this? So what was who was the patent owner company in that case? Okay, I'm not talking about, so you can go and check the Lundbeck and then a more recent Servier case. So they're about this practice. And in 2009, there was this competition inquiry by the European Commission. They look at the practices in pharmaceutical sectors quite closely as a result of all these arrangements. They start to think that something is wrong with this sector, okay? Since then, pharmaceutical companies are really, really careful. Even if they are having like a genuine settlement, they are always really careful, and they try to not to give any money to the generic company as a result of settlement, okay? If you are let's say there is this invalidity action or infringement action between you and generic company, you can obviously settle on this. It's good. And generally lawyers try to settle the cases as soon as possible, but generally we don't want to have anything like referring money in the licensing agreement, settlement agreement, because that can give rise to these pay for delay practices, okay? And finally, very quickly, R&D agreements, research and development agreements. Actually, they are good, okay? Research and development, no? So why undertakings come together and making research and development agreements? Because they are doing something that they cannot do independently, okay? So they are, maybe like not don't, but maybe like it's more efficient to do it together as well. So they are bringing their sources together. The source can be experience, their human resources, like their scientists working on different aspects of particular thing, and also their financial. Did I say financial? Anyway, so because financial is the most important one. Like let's think about, for example, this cancer, that pharmaceutical that can treat cancer, okay? But there are two pharmaceutical companies. They have expertise in different aspects of research and development of pharmaceuticals. And they said that, okay, maybe if we come together, we can do this. We can actually invent this, let's say, composition treating particular type of cancer, and they are making research and development agreements. So in essence, they are good. They are good for humanity. We encourage them, but they can be also used to cover up cartels. Okay, if this is the case, then we will be concerned, and we will look at them more in more detail, and also because so agreement is bringing sources together and working on something together, but generally R&D agreements also include provisions regarding how they will exploit the final patent right, okay? So we are working on it. If we come up with something, and if we get a patent for that, how we will use that patent, okay? How we exploit that patent. So that part of the agreement can be anti-competitive as well. So because of this, research and development agreement is something looks pro-competitive, mostly pro-competitive, good, but they can be anti-competitive as well, okay? And for that, we have the specific block exemption called research and development block exemption, and as all block exemption, it has some conditions, market share thresholds, restrictions, hardcore restrictions, and if you have and research and development agreements satisfying the conditions stated in this block exemption, you can be safe from the application of Article 101. Okay? Any question? Okay, let's have 5 minutes break and meet here. Actually, it will be at 6. Faster, but I start to feel anxious that we cannot finish everything on time. Then I will feel really sad. So in order to avoid that, try to go faster. Okay, this will be about IP and market power. So we talked about IP and agreements, and now we will talk about market power. So this things like this, the things that we will talk about will be related to Article 102. Okay. This is the outline of the seminar, and first we will talk about the elements of Article 102, and we will mostly focus on dominance and abuse. Then we will talk about what is exclusionary and exploitative abuses. Then we will look at different types of abuses: refusal to supply, tying and bundling, imposing unfairly high royalties, price discrimination, obtaining, acquiring, and enforcing IPRs. Okay? Let's start with elements of Article 102. So 102 is paragraph 1. Any abuse by one or more undertakings of a dominant position within the internal market or in a substantial part of it shall be prohibited as incompatible with the internal market insofar as it may affect trade between member states. Okay? So, what is that about, and what's the difference between Article 101 and 102? Can you see the difference?
Is this just about undertakings with a dominant position? Well, 101 is for every undertaking?
Yes. So in here, can we say that in Article 102 we have this like bilateral or multilateral relation? So you need to have agreement or decision or concerted practice. So you need more than one undertaking. Whereas in here, this can be unilateral action. So if you have a dominant undertaking, its action, its conduct can be subject to Article 102 if it's amount to abuse of that dominance. Okay? So there are some words in bold. Obviously, they are referring to the elements of Article 102. Okay? So first, undertakings again. Dominant position within the internal market or in a substantial part of it, there should be abuse, and that abuse should affect trade between member states. Okay? We will talk about them quickly, but we will focus on dominance and abuse more because it's important. Then in the second part, there are examples of some type of abuses, but this is not exhaustive list, okay? It is just like example, but if you look at the particular types of abuses, and if you look at these like A, B, C, D, you can see that you can actually fit them into one of them most of the time, okay? Because they are drafted like broadly, okay? Any question about Article 102? What? Okay. And one thing, there are some things that I put like small stars in here that I think really important. You can apply Article 101 and 102 together, okay? So let's say there is this dominant undertaking entering into an agreement with another undertaking. This agreement can be subject to Article 101, but at the same time, the act of entering that agreement can lead responsibility of liability of that undertaking under Article 102. So don't look at the things like either I will apply 101 or 102. They can be applied together, okay, to the same situation, okay? Yes. And other thing is that this article does not prevent to be in dominant position. Okay, you can be a dominant undertaking. Maybe you are doing what you are doing really good, and we are okay with that. But the problem starts when you start to abuse that dominance. Okay, so if you are a dominant undertaking, you have special responsibilities. You have to be more careful. Okay, why? From the right side of the class, why you have to be more careful if you're a dominant undertaking?
Because some behavior did by the non-dominant company that might be forbidden if you are a dominant company.
Yes, but why we are prohibiting these?
Because it is easier for them to influence the market.
Yes, perfect. So if you're a dominant undertaking, your conduct can affect the market more likely, okay? If you're a small undertaking, you can do whatever you want, but you cannot affect the market. Whereas if you're dominant, your conduct will affect the market. And our aim is to protect the competitive process in the market, so you have special responsibilities if you're dominant, okay? Any questions? One or more undertakings. So we start to talk about the different elements. So these like bold parts of the article, okay? As we did for Article 101. First, one or more undertakings. We already know undertaking concept. I'm not repeating it. Same with Article 101. My question is, so I said that this is unilateral conduct. So in Article 101, you need to have more than one undertaking because you need to have agreement or decision. But in this one, you can have one undertaking, dominant, and abusing that dominance. Then why we have more undertakings referenced in the article? It's on the slide. Yes. Because companies can act together. Yes, and we call that collective dominance. Okay? So legally independent undertakings, okay? Maybe they are not dominant themselves in the market, but when they come together, and this is not like coming together like making an agreement or anything, like adopting the same conduct, and that can cause collective dominance, and that can be abusive as well. One example, and this was real, it's from Turkey. It was in, I think, end of 90s, okay? At that time, there were only 2 cell phone operators in Turkey, okay? One of them was Turkcell, and I think the other one was Telsim, okay? So they were the only one in cell phone operators. Then I think the third one who wants to enter the market was Avea. Okay, I'm not sure about this name, but anyway, Avea needed to access the infrastructure, okay, in order to provide operating services. Okay, they cannot just enter market without having infrastructure. No, so they want these undertakings to give access to their infrastructure, and they both say no. Okay, they were not dominant by themselves in the market, but when they were together, they were dominant in the market. And decision was collectively, so competition authority says that you were collectively dominant in the market, so your refusal is and we have the like exact same article in Turkey. It was abuse of dominance, okay? Not the dominance of single undertaking, but the collective dominance of two undertakings, okay? Effect on trade between member states, same. Article 101, we already talked about this. So the effect should be beyond the just beyond one member state. And yeah, in order to apply Article 102, you have to have this effect, otherwise you cannot apply. Yeah.
Can undertakings be? Can you go the slide back? Can they be legally independent if they have the same name?
Yes, for like competition perspective, but as an IP lawyer, I don't know how you can have exactly the same name for.
It's like it's the license. For example, we have a grocery in Germany. It's called Rewe, and people license or take the name or whatever.
Okay.
So they have their own grocery shop.
Okay.
But if, for example, it's called Rewe Shahin or whatever.
Okay.
So they are legally independent from each other. So they take their own stuff. They just license the name.
Okay. So what do you think about that? When I say legally independent, what you understand? And this is a concept we talked before. What is being legally independent, or other way around? When you think two undertakings cannot be considered independent. We talked about this last week in terms of Article 101 when we were talking about undertaking. Single, blah 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 blah. Single. Yes. You were right.
I don't remember exactly, but something with single acting economic entity or something.
Okay. Omit acting, single economic entity. Okay. So then you have to look at this that definition, whether they can be considered as single economic entity or not. If they are not, then they can probably legally independent, and so you can use this collective dominance. Okay. Any other question about this? Okay. Effect on trade member state, we already talked. I'm skipping this one. Dominance. So dominance is important because in order to apply Article 102, you need to establish dominance, okay? If there is no dominance, there is no Article 102, okay? So if you're a lawyer and if your client is facing with abuse of dominance accusations, first stage you will go for is proving that your client is not dominant, okay? Then if you cannot do that, you will move to say that there is no abuse, okay? So dominance is important. And how we define dominance is, there is no definition in treaty. It is coming from case law, this United Brands case, which is like a really, really famous competition law case in the EU. And it's defined dominance as undertakings, economic strength, and ability to act independently on the market. So I'm so powerful that I don't care about anyone else, okay? I'm so cool, I'm doing whatever I want because I'm dominant, and so I don't need to concern about the other undertakings and try to compete with them because whatever I want, whatever I do, it will be okay, okay? Depends on the definition of the market. And we will talk about the definition of market. So if you define your market narrowly, what will happen? What is more likely? Narrow markets.
Bigger chance of being dominant.
Yes. So it's like the pool and fish. If you have a small pool, let's say this is fish. If you have small pool, this fish looks really big, but if you big pool, this fish looks small, no? Same applies in here. So market definition is really, really important, and you will see we always like try to, if I have a client facing accusation in terms of Article 102, I will do everything to prove that the market is really big, okay? Because then I can create this illusion as my client is like we undertaking in this market. And also in this, in terms of this criteria, dominance you need a dominance within a substantial part of the internal market, okay? And this is actually relating to limiting the EU's jurisdiction. Either you have to have dominance in whole internal market, or at least substantial part of the market, okay? But this is substantial part is not actually related to like where the undertaking is located or in terms of its market share. For example, let me see what's ABG oil case. Dutch petrol market, which was approximately 4.6% of the overall common market, found substantial, okay? So really small markets can be found still like substantial part of the internal market. So dominance in that market can still be caught by Article 102, okay? Any question about dominance? Let me see, wait. Yeah, okay, this part. No? Okay. Establishing dominance. So, as we said, it's really important to define market, and in terms of establishing dominance, to see whether an undertaking is dominant or not in a market, first you have to define the relevant markets, okay? And under this we have product and geographic markets, and then you have to examine the position of that undertaking in that market. So first you have to define the border of your pool, and then you have to look at the position of your fish in the pool, okay? And now we will first talk about identifying the relevant markets, product and geographic, and then we will move to the second stage, okay? Defining the relevant product market. Okay. This is, I think if you look at the, especially commission decisions or national authorities decision, probably like this part is one of the longest part of the decision, because there are like discussions and things, and because of the like the lawyers arguments trying to prove otherwise in favor of their clients. But in general, how we define the relevant product market is we look at the products or services which are close substitutes for each other, okay? So if you can substitute, let's say this is the product subject to investigation, then you look whether this can substitute this, okay? And if your answer is yes, you will include this one also in your market, okay? Then you will continue with this bottle, whether this can substitute this. If yes, you will include this, and it will go on like this, okay? And in order to determine whether they substitute each other, we have this test called SNP test. I don't have the long version of this in here. It's quite long. Let me see whether I have the... No, I don't have also here. What's the long version?
Small but significant non-transitory increase in cost.
Yeah, so the long version is that, okay? So what is... Actually, I think name also indicates what is SNP test, but what is SNP test? Have you ever heard about SNP test? You know, no. Can you tell us what's SNP test?
It's like the likeliness of like a price increase by year, how likely it is that one consumer will switch to another product
Yes,
that's
so
substitutable with the one offered?
yeah, so the aim is to find whether two products are, it's really hard word, I really appreciable this one, I hate them, whether they can substitute each other. Okay, so what they are doing is that, again, this is the product subject to the investigation, and they are saying that if I increase this price like tiny bit, okay, not too much though, like just like slightly, whether consumers of this product will switch to this. Okay, if your answer is yes, that means that these two substitute each other, so they are in the same market. Example can be Coca-Cola. Okay, you are drinking Coca-Cola and you try to see whether actually Pepsi is also in the same market with Coca-Cola. So you will ask the question of, when we increase price of Coca-Cola slightly, whether consumers will switch to Pepsi. Okay, if your answer is yes, Pepsi and Coca-Cola are in the same market, then you will move, for example, let's say Sprite, you will ask the same question, whether if I increase the price of Coca-Cola, consumers switch to Sprite. If the answer is yes, included in the market. You will continue like this, and for example, you can ask the question of, when I increase the price of Coca-Cola, whether consumers start to buy, I don't know, like Carlsberg beer. Answer is yes or no, depends. Depending on your answer, if your answer is yes, it's in the market, no, it's outside the market. Or maybe like orange juice, okay? Again, you have to ask the same question. United Brands, as I told you, it was like a really important case in this respect. And in this case, they discuss whether other fruits can substitute bananas. Okay? And the answer was no. Because bananas has like, you can carry with you, they have like, because it's easy to carry, they are soft, so it's easy to eat by old or child kids, and it taste is unique. So at the end of the day, they decided that it cannot be substituted. So the market was banana market, and that United Brand undertaking was dominant in banana market. Okay, so you can now think about, if they could convince the commission that, let's say, I don't know, not avocado maybe, but what can substitute banana? Let's say they accept that apple can substitute banana, grapes can substitute banana. So then the market will get bigger and bigger, and United Brands will not be dominant in that market, and then you don't need to go further to see whether they are abusing their dominance. So it's so important. Okay. Any question about SNP test, product market definition? Okay. And in one investigation, there will be more than one product markets. Okay, you don't need to have just like one. There can be different product markets. Geographic market, simple. Geographic area affected by the conduct. Okay. And what do you think about the factors that can be considered in this respect? So what will be the things that you use as a lawyer to convince the authority that actually that market wasn't affected by the conduct? So your client is facing with the Article 102 accusation, and you can say that, let's say you try to say that, okay, it's a German undertaking, and and the claim is that actually its conduct also affect France and Italy. What will be your, like, some arguments you can use? It's on the slide. Okay, so for example, language. For example, if your client is publisher, so if the undertaking is publishing German newspaper, you can say that it's ridiculous. I'm publishing German newspaper. How my conduct can affect friends? They cannot read German. I mean, in general, no. Or high transport cost. Okay, it's really like inefficient for me to transport my things there, so there shouldn't be any effect there. Or consumer preference, you can argue that there is no demand for your product in that market, and national regulation. Okay, yeah, I mean, it's sky is the limit. I think you can just like do whatever you can in order to show that particular market is not effective for them. Any questions so far? Am I going too fast?
No.
Okay. Yeah. Assessing market power. Okay, so now we complete the first stage. So we identify the relevant market. Okay, now we are in the second stage. We are looking at whether in that market our undertaking is dominant or not. Okay? Assessing market power. So first thing I want to highlight is market share is not equal to market power. Okay? What's market share? Yes?
It's the percentage of the market created on the same price.
Yeah. So for example, talk about let's say like United Brands. In that case, United Brands has, I think, had 45% of banana market. Okay, so that 45% of the share is market share of that undertaking. Whereas market power is something else. So remember, we defined it as not like market. For example, in terms of significant substantial market power, which we can say also dominance, then it's like you have that power to a certain extent that you can act independently, okay? And market share is just one of the indicators, and actually it's like probably like most clear indicators of market power. But it doesn't, like, they are not same concepts, okay? Because when we are assessing market power, we consider things beside market share, okay? So market share is something. First, you look at the market share of the undertaking. Then you also look at the market share of other undertakings in the same market. Then you also look at the market, whether there are barriers to entry to that market or expansions, or whether it's easy to enter that market, okay? And then you also look at countervailing buyer power. And we will talk all about them all, but for now, just, and these are all from guidance paper. If you haven't done so, please go and read. It's easy to read, and actually it's covering most of the things that we are talking today, guidance paper, okay? And it's in your reading list. Okay, so let's start with market shares. So we said that in order to see whether an undertaking is dominant, first thing, market shares you have to look at. Let's look how we are looking at them. So you have to look at the present situation of the market. What are the market shares in that market, okay? Not only the undertaking facing these accusations in terms of Article 102, but you also look at the market shares of the other undertakings in that market. For example, in United Brands case, what happened is that United Brands only had the 45% of the market, but the second biggest competitor had, I think, like 24% of market share, and that was something affected the decision in terms of that United Brand was dominant, because the market share of the second biggest just was the half of United Brands. So it's important to see what is the structure on the market in general, okay? You can have high market shares, but if you have low barriers to entry, and we will talk about barriers to entry after this, then even though you have these market shares, may not necessarily indicate that you are dominant, okay? Because then we assume that it's easy to enter this market. Yes, this undertaking has this market share, but anyone can enter this market as well. So there is like currently there's like this market power situation in the market. It can change easily, okay? In guidance paper, it says that if the market share is below 40%, it is unlikely that that undertaking is dominant, okay? It's not saying is that if it's under 40%, undertaking isn't dominant. It's only giving you guidance, saying that my experience show me that if the market share is under 40%, probably you don't have dominance in that case, okay? And this is 50% in United States, so they are more liberal in that terms, okay? If you have relatively high market shares for a long time, that can also indicate high barriers to entry. So you start to think that something is like, probably it's hard to enter this market because there is this undertaking having high market shares for a long time consistently, and that can indicate, so high market shares for a period can indicate market power as well, okay? But please always think that we are considering like this is like case by case analysis, okay? It depends on the situation, and different factors coming together indicate something, okay? What was the market share? Yeah, I think this is all what I... And it's the first thing that we always look, because it's like really clear. Once you define the relevant market, it's easy to find market shares, and it's a good place to start to your assessment, okay? Any questions about market shares? Okay. Barriers to entry, I like actually briefly already mentioned, but in essence, whether it's possible to enter that market or whether it's easy to expand in that market. So it can be like related to entering the market, just like a new competitor, or as a current competitor, whether actually you can expand your practice business in that market, okay? And it's important, as I said, if, for example, if you have a market with high barriers to entry, for example, then relatively low market shares can still lead to dominance, okay? Can you think about high barriers of entry situation? What can be constituted as high barriers to entry?
Regulation.
Yes. Who said the regulations? Yeah. What kind of regulation? Okay.
Like regulations that need to obtain
If it's hard to comply with the conditions to get that permission, yes. Or maybe like And I think that can happen like sometimes in this regulated sectors you can have maybe like only certain amount of undertakings maybe, because they can limit the authorization that they are giving. I don't know, I have that kind of feeling. I think like in telecom sectors and things like this, that can be cases. Yes. What else?
The actual cost to enter airplane is really expensive, so that's a high barrier to get to that market.
It is, but see, how we are looking at this is actually not more like whether you have the sources as an undertaking to make that investment, but we are looking at from more market perspective. So if you want to enter like air transportation sector, we assume that you should have money to do that, okay? But the problem can be, in order to do that, you need to have slots in airports, okay? And if all the slots are full, and if you cannot get any slots for your airplanes, then that can be considered as barriers to entry, okay? Because I mean, you cannot go and build your own airport, no? Same can happen for ports. If you want to like transportation with ships, you need to have access to ports, and if you cannot access the ports, then that can be barriers to entry. Yeah, and this will be our thing. So if there's a patented technology that you need to, or actually in generally IPR protected thing that you need to have access to compete in that market, that can be also indicate barriers to entry. And my last statement in here saying that, and this is the rule in EU, just having IPR, like being owner of IPR, do not necessarily confer dominance, okay? But it can help an undertaking to become dominant in the market, because it can create that barriers to entry, okay? If it's like something you really need to have in order to compete that market, okay? And we will talk about this when we are talking about essential facilities doctrine, okay? And like actually in general, high fixed cost to enter into a market is barriers to entry in general. For example, in this case, this undertaking needs infrastructure entering this market, and they cannot go and set up that infrastructure all around in this case, Turkey, to be cell phone operator, okay? So they need that access, because it's not viable for them to set up second infrastructure. So that infrastructure can be considered as barriers to entry. Or maybe like maybe this is like an extreme situation. You can think about, for example, if you need to build this like a really state-of-art factory or like a distribution network in order to compete in that market. It is something, if you have money, if you have time, if you commit, you can do it. But whether, like considering the market, whether it's like something reasonable to do in terms of, for example, distribution network, and that was Oscar Bronner case. It was from, I think, from Austria, and there was this newspaper with distribution of newspaper around the country, and their distribution network was like amazing, and another undertaking want to benefit from this distribution network, so say that you also distribute my newspapers as well, and they say no, and they argue that it's not viable for me to create the same distribution network, okay? They weren't successful, but they argue that it wasn't viable considering the size of the market to establish not same, but a distribution network as good as Oscar Bronner's one. Okay? Yes. Okay. Mm-hmm. Yeah. Yes, it's actually a really good example. We call that switching cost, actually. So, for example, if you think about like an undertaking, but more like a company undertaking, and let's say, I don't know, like, again, let's say you're a publisher and you have all these like printing equipment, like machines and everything in your company. So you are printing with that, and you bought all these machines from company X, okay, or maybe let's say, okay, Samsung. So they trained all your staff to use all these machines, and you have been using those machines like for years. So you know like inside out how to do that. And now if you want to switch from Samsung to, I don't know, are they? Do they have printing machines? HP. Okay. If you want to switch to HP, then that means that you have to get rid of from all these machines. Then you have to buy the HP machines. Your staff should be trained about HP stuff, and that can be something off-putting the potential consumer. And if it's like a serious problem, that can be also considered as barriers to entry. Okay? We call that high switching costs. Not only money, but in general, all the things that the consumer should do in order to switch from one to another. Okay, let me see. This will be I think we can just like finish it here. No. Countervailing buyer power. This is another thing this will be the last. Another thing you have to consider when assessing market power. So maybe you have an undertaking really looks like dominant, but if it has a really powerful consumer against it, then we call that countervailing buyer power. So buyers' ability to act independently. You can think about, for example, chipsets market. Okay, you can have this like undertaking, really like producing state-of-art chips, and they may be like in that small market, they have high market shares. But if their consumer is Apple or Samsung, probably there is that countervailing buyer power in this case, because their buyer is really, really powerful, so they kind of balance the situation. Okay, I have question about this for next week. Why do you think this cannot be relied in general in order to like in order to correct the market? Okay, countervailing, it's something like balancing the situation. You have dominant undertaking, and countervailing buyer power can balance that. But it is not that you can rely on that heavily in terms of preventing the abuse of dominance in general in the market. Why do you think this is the case for next week? Okay. If you have any questions, we can just like talk outside. Okay. See you next week.